Good evening. We are moving forward to another topic, Articles 1390 to 1402, Chapter 21, Avoidable Contracts. Article 1390, the following contracts are voidable or annullable even though there may have been no damage to the contracting parties. When we talk about voidable contracts, these are, though it possesses all the essential requisites of a valid contracts, meron talaga siyang meron talaga siyang essential requisites which constitute the valid contracts, but one of the parties is incapable of giving consent, or consent is vitiated by mistake, violence, intimidation, undue influence, or fraud. For example, if you contracted with a minor, then that is a voidable contract. When you contracted with a spouse na hindi without any consent from his partner, from his uh, husband or wife, so that is a voidable contract. The following contracts are voidable: those where one of the parties is incapable of giving consent to a contract. Second, those where the consent is vitiated by mistake, violence, intimidation, undue influence, or fraud. So dahil because of the intimidation, because of the violence, tinutukan siya ng baril, and then because of that, napapirma siya sa kontrata. So that is voidable contract. These contracts are binding unless they are annulled by a proper action in court. They are susceptible of ratification. If there is no claim to annul the contract, na ipaulang bisa ang contract, then patuloy ang effect ng contract. Unless if there is a claim, if there is a there is a case in which the contract may be declared voidable, no? So there would be an annulment of the said contract. Otherwise, magpapatuloy ang effect ng kontrata. It must be observed that in a voidable contract, all of the essential requisites for validity are present, although the requisite of consent is effective because one of the contracting parties does not possess, like what I've said, does not possess the necessary age requirement, the necessary legal capacity, or because their consent, no, because of the mistake and violence, napapirma siya sa kontrata. So that is voidable. Consequently, if consent is absolutely lacking or simulated, the contract is inexistent. So it's not voidable, but it is inexistent. Article 1391, the action for annulment shall be brought within 4 years. Otherwise, kung hindi maglapse ng period ng 4 years, you cannot file a annulment. In cases of intimidation, violence, or undue influence from the defect of the consent ceases. So the reckoning period of the 4 years is from the time the defect of the consent ceases. In case of mistake or fraud, from the time of the discovery of the same. Kung hindi pa na-discover ang mistake or fraud, hindi pa magsa-start ang 4-year period na prescription. And when the action refers to a contract entered into by minors or other incapacitated person, from the time the guardianship ceases. So for example, they contracted a minor, and then si guardian in behalf of the minor, minor, and then after 18 years old to 14 years old pa siya. So after 18 years old pa niya, pwedeng i-annul ang contract. So yung 4 years magsa-start sa 18 years old. Kung nag-contract si 14 years old and 18 years old, 'di ba, voidable ang contract. Pero at the moment na mag-i-18 pa si 14 years old, so hindi magsa-start ang 4-year prescription na sinasabi ng 1391. Doon magsa-start kapag 18 na si 14 years old. Okay? Article 1392, ratification extinguishes the action to annul a voidable contract. When we talk about ratification, it means that one voluntarily adopts or approves some defective or unauthorized act or contract which, without his subsequent approval or consent, would not be binding on him. It indicates an intention on the part of the ratifier to be bound to the provisions of the contract. Article 1394, ratification may be effected by the guardian of the incapacitated person. Example, a contract entered into by an incapacitated person may be ratified by the guardian or the injured party himself provided he is already capacitated. So if minor pa, pwede si guardian mag-ratify ng said contract. As legal representative of the wards, guardians have the power to contract on their behalf. Hence, they may also ratify contracts entered into by their wards. Article 1395, ratification does not require the conformity of the contracting party who has no right to bring the action for annulment. Ratification is a unilateral act by which a party waives the defect in his consent, and the consent of the guilty party is not required. Otherwise, he can conveniently disregard his contract by simply expedient of refusing to give his conformity. So kung guilty party, hindi na kailangan yung consent ng guilty party. 1396, ratification cleanses the contract from all its defects from the moment it was constituted. In Article 1396, for example, B force S to sell the latter's horse. Later, the horse gave birth to a colt. So yung baby ng horse is called colts. If S should ratify the contract after the birth of the colt, who is entitled to the colt? So sino yung entitled ng colt? Yung pinanganak ng horse. Of course, si S. Because ratification has a retroactive effect. So mag-recon siya. Babalik siya kung saan nagmula yung contract on the date. For example, yung date is January 20 ng contract. So it will recon on January 20. Kung kahit ang nag-execute kayo ng contract on February 20, kung ano yung nasa stipulation ng February 20, mag-retroact yun, mag-take effect kung kailan nagmula yung contract, yung January 20. It validates the contract from the date of its execution. If the horse had been sold by B to C who acted in good faith, the subsequent ratification by S of the sale to B cannot be prejudiced C. You have to take note on that. 1397, the action for annulment of contracts or cause mistake base their action upon these flaws of the contract. And example, S sold parcel of land to B. The consent of S was vitiated by fraud. And subsequently, S sold the same lot to C. So in this case, C can bring an action to annul the sale. So that is what is meant by Article 1397. 1398, an obligation having been annulled, the contracting parties shall restore to each other the things which have been the subject matter of the contract, with their fruits and the price with its interest, except in cases provided by law. In obligations to render service, the value thereof shall be the basis for damages. In Article 1390, there are duty of mutual restitution upon annulment. So first, if the contract is annulled, the parties as a general rule must restore to each other. So first, the subject matter of the contract with its fruits, and the second, the price thereof with legal interests. And the second one, in personal obligation, if it is a personal obligation where the service had already been rendered, the value thereof with the corresponding interests is the basis for damages, recoverable from the party benefited by the service. In Article 1399 then, when the defect of the contract consists in incapacity of one of the parties, for example, minor or their husbands and wife did not consent to the contract, the incapacitated person is not obliged to make any restitution except insofar as he has been benefited by the thing or the price received by him. That's very self-explanatory. Article 1400, whenever the person obliged by the decree of annulment to return the thing cannot do so, hindi niya gagawin, because it has been lost through his fault, he shall return the fruits received and the value of the thing at the time of the loss, with interest from the same date. So you could not exonerate yourself na nawala na yung thing na yon. You could not raise that one as a defense. So you shall return the fruits, kung whatever fruits, kung ano yung naging interest ng thing na yon, no? And plus interest from the same date. Article 1401, the action for annulment of contract shall be extinguished when the thing which is the object thereof is lost through fraud or fault of the person who has a right to institute the proceedings. So hindi ka pwedeng mag-institute kung ikaw na mismo ang naka-lost or you are employing fraud. No? It should be the aggrieved party who shall file a claim. If the right of action is based upon the incapacity of any of the following of the contracting parties, the loss of the thing shall not be an obstacle to the success of the action unless the said loss took place through fraud or fault of the plaintiff. Article 1402, as long as one of the contracting parties does not restore what in virtue of the decree of annulment he is bound to return, the other cannot be compelled to comply with what is incumbent upon him. So here, when a contract is annulled, a reciprocal obligation of restitution is created. The return by one party of what he is obliged to restore by the decree of annulment may be regarded as a condition to the fulfillment by the other of what is incumbent upon him. So in effect, there will be no annulment if the party cannot restore what he is bound to return. This is true even if the loss is due to a fortuitous event. For example, V forced S to sell the latter's horse. No, the contract was annulled by the court at the instance of S. If the horse died through the fault of B, Article 140 governs. If the horse died due to a fortuitous event, S can refuse to return the purchase price with or without the fault of B, or a BS as injured party, with or without the fault of B. S as injured party has a right to demand the value of the horse with damages. So that is a voidable contracts. Later on, we are going to deal with another contracts, yung mga those contracts which is not unenforceable. Okay,